for the introduction. In Malaysia, the problem of child abuse has received more attention lately, especially whenever it comes to caretakers working in child care facilities. This issue has been exposed one more time by a recent case in Besut, Terengganu, where 2 babysitters has been put under control after reportedly assaulting 2 young siblings at a registered kindergarten. Significant ethical and legal concern about the protection of children's rights under Malaysia law are brought up by this case, which that includes the physical abuse of 1-year-old girl and her 3-year-old brother. In addition, considering the larger obligation of people and organizations that have been charged with providing childcare, this seeks to analyze the incident's legal implication, especially as seen through the specific perspective of the Child Act of 2001.
This case involves 2 babysitters arrested for allegedly abusing 2 siblings, a 3-year-old boy and a 1-year-old girl, at a registered nursery in Kampong Raja Besut, Terengganu. The abuse was exposed after the mother was shown a video revealing the abuse, in which the boy had a small swelling on his forehead and the girl had a pinch mark. The suspects, aged 26 and 50, were remanded for 6 days starting 7 September 2024 by Sessions Court Judge Ahmad Fadli Mahmud. This investigation was conducted under Section 31, Clause 1, Clause A of the Child Act 2001 relating to child abuse offences. The nursery is registered under the Social Welfare Department, confirming it as a recognized child care facility. The arrest followed the viral spread of the video on social media, bringing the abuse to public attention. The remand period allows police to complete the investigation and gather sufficient evidence for prosecution. This case highlights serious allegations of child abuse by caregivers in a licensed nursery under Malaysian child protection laws.
So in this case, it is clearly shows that battery has a cure. There are 4 elements that should be fulfilled in a case to be called as a battery by a law. So the first element will be the intention of the defendant to apply force. In the video, we can see the caretakers intentionally using force against the child. Their actions were not accidental. They know that they act aggressively and roughly. This shows clear intentions to apply force, which is the first element of battery. So the second element will be the act was under the defendant's control. The second element is also fulfilled because the caretaker were in full control of their action. No one was forcing them to do so. They chose to handle the child in a harmful manner, making the act fully voluntary and deliberate. So the third element will be contact or application of force occur. In the video, there is clear physical contact between the caretakers and the child. The child was grabbed, possibly hit or shaken. This confirmed that force was applied, which is satisfied the third element. So the last element will be the fourth element, which is without plaintiff consent. The child is a minor and surely cannot give consent. Also, the parents definitely did not give any permission for such treatment. This means the physical contact was unauthorized and unlawful, completing the final element of battery. So, to conclude, based on the video evidence, all four elements of battery are present in this case. This means the caretaker's action can legally be classified as battery and possibly criminal child abuse under Malaysian law.
There are few defenses available for these cases, and the first one would be self-defense. It is allowed for someone to use a reasonable degree of force for protection of himself or any person against any danger that is applied by the force. It is also said that the relationship of the parties to be protected may be relevant to the reasonableness of force use. However, in this situation, the defendants did not have any valid reason to use a reasonable degree of force towards the children, as those children did not bring any danger to them. Other than that, even though those defendants have a relationship as colleagues, there is still no reason for them to abuse those children because they have nothing to be protected from those children, as they brings no harm to them, and instead it is their responsibility to take care and treat those children gently. Thus, self-defense is not applicable for defendant to defend themselves. The second defense that is available would be consent. It is said that consent must be genuine, not obtained by force or threat. However, in this case, the children never grant their consent to be abused by the defendants. They also never agree to be abused by the defendants. Thus, consent is not applicable for those defendants to defend themselves. So, for the conclusion is, in conclusion, it is proven that those caretakers were guilty. Through this evidence of this case clearly shows that the action of the caretakers can be classified as battery. All the elements of the tort of battery are present, which is intentional application of force, control by the defendants, physical contact, and absence of consent. The caretakers' actions were not accidental and fully under their own control. Furthermore, the available defenses such as self-defense and consent do not apply in this situation, as the children are minor and the child parents never agree to such treatment. So, the child parents can sue the babysitter in civil court for the battery.